Any apologies, Anila?
No, Minister.
I think that Senator Kamina Johnson, sorry, Minister Kamina Johnson Smith said she either will be late or she may not be able to make it. But we're going to continue from where we left off yesterday. What I hope we can do, Kamika, we're going to start at clause 9, continue, and then depending on how we go, we can then, tomorrow we can, do a reassessment of all the clauses we've done this week, or we can continue to do the additional clauses. But Kamika, let us start out with clause 9. So you're ready, Kamika?
Yes, sir, I'm ready.
All right, so
let me share my screen.
Go ahead.
Okay. And we had, remember though, sir, that Senator Motley had in the, right.
In relation to clause 8, she had reserved her position, okay?
Okay, all right.
But
okay.
Actually, as a summary, we only agreed on one clause yesterday, clause 1. So the other 4 clauses that we dealt with, we will have to return to, okay? So there's no agreement. But we start out with 9 and see how we get along.
All right, sir. Well, with regard to 9, so several entities indicated that they were concerned about the security of the databases, and these were JETS, BOJ, 876 Solutions, and several of the smaller, less substantive submissions. JFJ also went on to recommend that limitations should be placed on the kind of data to be shared via a unique identifier. And Norman Manley Law School actually indicated that the buildings explicitly indicate any conformity with the GDPR. Now, MNS, right, in response to that, the technical team believes that the bill sufficiently sets out the security framework. The legislation must be read as a whole. And so provisions such as clauses 3, 5, 6, 23, 27, and 30. So 3 would be the objects, 5 would be the functions of the different, of the authority, 6 of the governing, well, right now, Board of Management. 23 would be the security. Section 27 would refer to the oversight body, and 30 would refer to the secrecy and confidentiality clause. Those clauses clearly outline that there's a threat of security of information that runs throughout the national databases, and indeed throughout as it relates to information generally in the possession of the authority. Additionally, the authority would be subject to observing constitutionally protected right of privacy, as well as to the Data Protection Act of Jamaica. So we did not believe that it needed to be changed in any way.
So the technical team doesn't see any need for any change to clause 9, because as you're explaining, Kamika, technical team is satisfied that 9, the encryption protect the database. Is that correct?
Yes, sir.
Come on. Permit me, if my recollection is that one of the concerns raised about the database centralization of it, I'm not sure if that issue has been addressed.
Okay, but Madam, hello?
Yes, we're hearing you.
Right, I agree with the technical team. And what I want to suggest is that in a short time, we should begin to educate Jamaicans on the Data Protection Act and the strong legislation that is there to protect personal data. With regards to the comment from the AG, the database is not necessarily going to be, just one database centralized in government. the technology will be such that we'll be able to pull information from other databases. So I think in people's minds, they're thinking everything is going to be concentrated. If I'm wrong, let me know, but I didn't think so.
That's my understanding to Minister Williams.
Thank you, Minister Williams. Through you, Chairman.
Yes.
It's a matter of the explanation that we provide to the public.
Right.
Concerns are raised. It is primarily from that angle.
I think in our report to Parliament, we should put the need to give a full, proper and expanded explanation as to how the database will be protected and secured, okay? So, Anila, for the report to Parliament, the concern with clause 9 is to be able to explain and as best convince the public that the data will be protected, okay?
Okay.
All right, so clause 10 then.
Sorry, Minister,
Clause 9.
Chairman, Minister, can I
Sure.
interject in respect to clause 9?
Right.
And it comes to 9(8).
Subsection 8.
Subsection 8, yes, and
Yeah.
particularly C, where there is a provision for conviction before a circuit court.
Right.
And as you know, the circuit court sits with a jury and you have judge alone matters in the circuit court. It is not, is it that we're going to jury or judge alone it does not.
I don't think we need to put in anything there, Senator. Do you think we should be saying before, if we just a circuit court, that can be decided later whether it is just a judge? What do you think? Or you don't necessarily want to put before you would want to say,
no, Member Sinclair is correct. It does need some clarity.
so should we say before a judge?
As a general rule, trial in the circuit court is a trial with the jury, as
Right.
Member Sinclair has pointed out. I don't believe it was the intention for these offenses or the accessing the database, unlawfully accessing the database, or without lawful authority, willfully accessing the database without lawful authority, willfully modifying the content of the database without lawful authority, intercepting or causing to be intercepted any function of the national database.
Right. Could we then just say AG before a judge in a circuit court? So it makes it clear.
It would have to be, it's trial before the High Court by judge alone. There's a formulation the CPC can use, similar to what we have in other legislation.
So CPC, I think we would take the recommendation that it should be before a judge in the High Court or in the circuit court. CPC.
Yes, Chairman. That is with specific reference to which of the provisions.
And should we also do it for 10 subsection 10A?
10B, Mr.
10B, sorry, 10B, yes. So we do it for both 8C, subsection 8C and subsection 10B, and make it clear that it's before a judge in a circuit court or the High Court. You have the formulation, CPC, okay?
Yes, Chair.
I agree with that. Okay then.
Thank you.
All right. 10, Kamika.
Pardon me, there were a few others comments for 9. All right. Right, so MNS had queried whether the term function that was just read in the offense that was just read out by the AG was to be construed in accordance with the Cybercrimes Act. And JCF actually suggested that what we could do, or what the committee could do, was indicate that it is indeed within that context by including it in the bill. I'm trying to make sure you can see properly, but
yes, I see it. CPC, what do you think? Is it necessary?
Yes, Chairman. We would amend subsection 11 to include reference to function so that it also incorporates the definition in the Cybercrimes Act.
Okay.
Okay,
Anything else, Camila?
Yes, sir. All right, and the following concerns now were raised regarding alteration of information in the databases. So the the Healthy Society recommended explicitly placing a limitation on the alteration of sex to that stated on a person's birth certificate. Jambar was also concerned that alteration of data wasn't restricted to requests from the individual who owned the data, but that other persons could in fact request alteration, and they recommended indicating in the bill that only the data owner may request alteration of his or her information. The response from the technical team is that the bill doesn't require amendment for the reasoning that the Coalition for Healthy Society requested it because the tenets of the Constitution of Jamaica, which only accommodates male and female, and which does not at this moment accommodate any alteration of sex stated on a person's birth certificate, would be the governing rule for this particular instance. Reference was made to the CPC as it related to Jambar's query.
Can I make a comment about the first part, what you have just said?
Ransford, we are not seeing you. Member. And remember, when you're speaking, just put on your video because you're on PCPJ. Okay, we are seeing you better now. Go ahead, Ransford.
Yeah, the explanation, as I understand it, Ms. Facey, is that the Constitution recognizes only, is it male and female? Am I correct?
That is correct.
That doesn't stop somebody from changing their sex and asking that the information be changed. How does that prevent? I don't think that the Constitution prevent a Jamaican from, say me, for example, converting myself to female and then so on. If I do that, does the Constitution prevent me from demanding a change? I don't think so.
Well, no, it doesn't prevent you from demanding a change. But, well, I suppose then it would become, as you rightly stated, an operational matter. And operationally, the sex would be taken from the person's birth certificate within the the framework of the authority. So you're correct. It's not really the tenets of the Constitution of Jamaica. That was really, as it regards the point that JCHS had made had also gone on to speak to matters such as someone who believes that they ought to be female, even though they really are a, what did they call it, a little girl, even though they're a huge man. That was one of the examples given, and that is why we had actually indicated with regard to the Constitution of Jamaica.
It sounds a bit far-fetched, Minister, but it is not. No, it is going to be, as we become and we follow others, a matter that we are likely to have to grapple with. And I have a conversation about it. Anyhow, all I'm saying is that I don't think the Constitution in that provides the answer.
May I ask, what is it, which just remind me of the specific clause or subclause that we're considering?
Pardon me, AG, you were in and out.
Just remind me of the specific clause or subclause that we are considering in relation to the submission of the JCHS and Jambar.
They had submitted on this at clause 9. We're looking at the national databases. So I can.
Which subclause of 9? Which subclause of 9?
I'm going over further so you can see the specific. They really were speaking. They didn't, in that particular, in JCHS's submission, AG, they were really speaking to us and to the authority, entering particular type of information into the database. So it was a general comment. I'm trying to find it for you.
I see it. Clause 9, sub
Right here.
6.
Right. Okay, this is
5 and 6. Information stored in the databases shall not be altered except in the manner provided by the Act or regulations made under the Act.
Right.
And at any time after an individual, I'm sorry, let me put on. At any time after an individual is enrolled, that individual may request in writing to the authority the alteration of any information, identity information, with respect to that individual, that the individual claims to be incomplete, incorrect, misleading, or otherwise in need of alteration. So the concern is that it only allows for a change by the individual, the enrolled individual.
No, the concern that Jambar was indicating was that their reading of that subclause was that it allowed not only the enrolled individual, but we actually believe that the reading there clearly indicates that it is the enrolled individual who must request that alteration.
And no one else.
Right.
But this is under the area that this the JCHS.
No, this is Jambar, Senator.
The question of JCHS.
Right, JCHS. Now let me go over. Right. So amendments that, are you seeing Senator Braham and AG? Yes. Here it is.
Yes, thank you, Ms. Spacey.
Okay, so I think we're fairly satisfied that Senator Braham, that the individual can put in that request, but no one else. Okay.
Yes, but we have not addressed the JCHS issue. We may disagree, but at least we should address it.
I'm not too sure we can deal with that in this bill, Senator Braham. I think that's a matter that, you know, is outside the jurisdiction of this bill. What do you think? I mean, it could be a constitutional issue, which the court will have to decide and then give direction, but I'm not too sure that this can accommodate.
I'm sorry, Chairman, through you to Senator Braham. Yes. What's the issue that you're suggesting the committee addresses, Senator Braham?
There was an organization, if Ms. Spacey would just repeat what the organization said.
JCHS, the Coalition for Healthy Society, yes.
And so that was given is that the Constitution addressed it. And I was saying the Constitution does not address it. And the question that they have raised. Now, the answer to the question is what Minister Chuck says, but at least we should at least appear to understand what they are saying and then say we can deal with it.
Well, that's my position.
So the request is to only permit inclusion of the sex/gender that is assigned at birth.
That's right.
Right.
And I mean, I don't know, we cannot address all the possibilities that may occur after a birth certificate is issued. So the person who wants to change on the birth certificate may well have to go to court or some other legislation, have it change, and then it would automatically affect what we do in the NIDS bill. But to my mind, we will be dependent on what is on the birth certificate. So if the individual successfully, either through the court or in another piece of legislation, have the gender changed, then obviously the NIDS bill will have to take that into consideration. But I don't think that the NIDS bill should really, you know, acknowledge or change at the request of the individual when the birth certificate is imposing or has a particular gender. What do you think?
So, Chairman, the issue of gender fluidity, as I understand the concept to be coined, as Member Braham has said, is indeed a thorny issue. Within our jurisprudence, under our law, the gender that is recognized is the gender assigned at birth, as of now, not one
that would be my position.
By operation or by choice.
Fine.
That perhaps would be the best and highest explanation we can give at that time. That Jamaica law, as it recognizes gender assigned at birth by virtue of, I guess, the sex organs.
Right.
Does not, at this time,
we're not going to look
deal with alteration by operation or other choice.
Fine. So that is my position.
9.6, Chairman, the last clause of it, which says, at any time after an individual is enrolled, that individual may request.
Senator. Anila, could you please send a link to Senator Hill again? He's trying to get on and he has not been able to get on. So send a link to Senator Hill. And I think Senator
morning, colleagues. Good morning. This is Dark and
can I cut?
Okay. Yeah, continue, Senator.
An individual is enrolled. That individual may request in writing to the authority the alteration of any identity information with respect to that individual the individual claimed to be incomplete, incorrect, misleading, or otherwise in need of alteration. That last stanza there, or otherwise in need of alteration, would that cover my attempt to be converted to another sex?
Kamika, you want to respond to that?
May I just ask before, Chairman, whether Senator Braham, if I understand you, are you saying the concern is with the last clause of the clause or otherwise in need of alteration that they provide for a mischief that was unintended?
That's what I'm saying. Wouldn't that allow the authority to say, okay, we are convinced that we are otherwise in alteration?
It does allow for what you are querying, I believe, but it also allows for other alteration to take place of the information in the database. Yeah. But I see your point.
But I think that's what the JCHS is saying. They would like that.
They're asking for a deletion of that clause?
Well, I can't say that because I wasn't there, but I'd have to realize.
No, if I may, they were actually asking us to put in a proviso to indicate that it has whatever is the alteration cannot change what was stated on the birth certificate.
Right. So the only thing that we would suggest, Senator Graham and AG, is that, I mean, in discussion, if they can get that change on the birth certificate, then, you know, the NERA would follow suit. But I don't think the NERA could adopt a new gender, which is different from what is on the birth certificate. That would be my view. Okay, so can we just leave it as it is then?
Sorry, excuse me, Chair.
Yes.
Yes. No, I think that's exactly the issue that the JCHS is trying to address, because there is nothing right now that is saying what you are saying. So what they want are words put in the bill to say that no change in sex can be recorded, which is not in accordance with the birth certificate.
No, but
That's exactly the point. It's not in the bill yet.
But SG, with due respect, we're using the birth certificate.
Where? But where is that in law? Yes, I hear you, but where is that in law?
No, because
Chairman, and I think
in the enrollment, we're using the birth certificate as one of the.
no, but where is it in law that says that it can only be that, especially noting the words or otherwise in need of alteration? I think that is why the JCHS has made that submission.
So are you saying that we should put unless
I'm not saying anything, Chair. No, I'm not saying it. I'm saying that's the submission of the JCHS, which I don't think is being fully considered.
Okay, so suppose we put in then Senator Graham and SG, unless changed on the birth certificate.
But Mr. Chairman.
Would that be satisfactory? CPC, could we put that in?
Hold on, Chairman. Let's just hear.
Mr. Chairman.
Senator Sinclair is trying to come.
I am looking at other clauses that is contained here, which is like clause 12, the documents that would be used for verification of identification. And it speaks to the birth certificate. So if the birth certificate has the person described as a male or female, as the case may be,
yes,
it will be because a person makes a transition.
Then
it's not amended on the birth certificate.
Well, that's what I'm saying, Senator Sinclair. Then
I'm agreeing with you, Chairman. I'm agreeing with your position.
Yes. But the point of the SG is that the particular civil society group is saying that it should become clear in the bill itself that it cannot be changed unless it is changed on the birth certificate. I mean, implying. And so the issue there is whether or not we should put in a clause to say that the gender is determined by what is on the birth certificate. I mean, this is my understanding that is what it says. But
Chairman?
Yes.
I think the SG is correct in pointing us to the need for clarity in the response, because even at clause 12, which so the menu of documents that may be consulted in order to verify the information, if you look at J, which says any other document containing identity information of the individual, conceivably that category could be a medical certificate. So if the intention is to use the gender assigned and recorded certificate, then we may need words to so specify. And I think that is the point that the Learned Solicitor General was directing us to, because what is contained at clause 12 does not say so, even though it lists the birth certificate as a document.
Well, if
used.
Well, the question we could ask CPC, we could say if you look at clause 11A, 11(1)(a)(6), whether the individual is male or female, we could add as determined on the birth certificate.
Of course, so this is also a policy issue. I mean, we are doing, you know, the fact that JSH has raised it doesn't necessarily mean that we should do anything about it at this stage. But are we declaring anything, a policy statement that has not been considered? What's the ramification of it, etc., etc.? I personally, for myself, would agree with it, but I just want to make sure that we have considered every.
Okay, all right. So,
but Mr. Chairman, I thought when this came up, as we were going through the various submissions, it was agreed that we were going to look to the birth certificate of the individual.
Absolutely, that's my understanding. But what is happening is that the discussion has taken on the turn, the Minister Williams. Suppose the individual can get the court or the birth certificate changed to say that they are female instead of male or vice versa. Should the NERA immediately uses the changed birth certificate, as the case may be? Yes,
Chairman, if I may. So Senator Braham reminded that the policy issues, we have to, in effect, take care with the policy issues, but we can say clearly that the policy on gender and the policy of the administration accords with the law. I believe that the suggestion you made in respect of just adding language after determination by the reference to the birth certificate could address the concern and and words should indeed be added to address the concern, and sufficient until the day when we progress beyond where we are.
Okay, so when we get to 11, we have a look at 11.1 is Roman 6 to see whether we should add that clause, okay? So we can move then from 9 to 10, clause 10, okay? We will address that point again at 11 when we get there. So go to 10, Kamika, the enrollment.
All right, sir. With regard to clause 10, the JFJ coalition recommended an expansion of the information to be provided to an applicant upon enrollment. So the context of this is that upon enrollment, an individual must be told certain things, how their information will be used, the fact that the information will need to be verified, and those other matters. And the JFJ indicated that the authority should also be required to expressly inform applicants that upon enrollment, there is no guarantee that their information will be deleted once they cancel that enrollment. And the public defender also recommended that the applicant should be informed of the risks associated with needs, such as access to an individual's identity information. And the Love March movement recommended that applicants should be specifically told that their data may be shared with different entities. The technical team's response.
Wait, no, just a second. You're saying that the data will be shared or authenticated?
No, this is the LMM's recommendation. Sorry.
That?
That they.
What's the recommendation, Kamika?
Right, they had indicated that applicants should be specifically told that their data may be shared with different entities.
But can that be? How can we say what should not be?
Yes, well.
I mean,
I'm just indicating what was said.
Mr. Chairman.
Yes, Minister.
In terms of data sharing though, the data owner would have to be told that the data is being shared, except for security reasons based on the Data Protection Act.
No, but it's not shared. I don't like the term shared, which gives the impression that it will be divulged. My understanding at all time is that it will only authenticate. I don't.
Right, but if it has to, let's say it's it has to be used for security purposes.
Only for security.
Then, right, only for security, or based on my understanding of the Data Protection Act, if your personal data is going to be, well, you don't like the word shared or used by any other entity, then you have to be notified except for security purposes.
Exactly. So your formulation is what I understand, Minister Williams. The data will only be shared with the permission and consent of the individual, save and except for security purposes. And for those security purposes, it has to be approved by a judge in chambers. Okay, so nothing is wrong with that. Is that the understanding, Kamika?
Right, sir. Yes, that is the understanding, but there was nothing specific in 10.2 which indicated that identity information may be retained. And accordingly, that was the only recommendation that was addressed in the response from the technical team, where on enrollment, or rather upon application, the bill should also state that identity information may be retained in accordance with the Data Protection Act, even after cancellation of enrollment.
I think that is, yes, Minister Williams.
Chairman?
Yes, go ahead.
You know, my preference is for us to actually review the words that we use in the clauses instead of giving an indication of what we believe might be there, because the intention of Parliament is going to be ascertained from the actual words used. Since the issue that is being considered has to do with what the individual is to be told upon enrollment, may I respectfully suggest that we look at the clause itself, particularly 10.2, and just to see if what is contained there is sufficient to address the issues. And also I would like to query some of the language in the clause. So may I respectfully ask that we just look at it, since this is one of the bones of contention, given that the framework is a voluntary one, the registration is voluntary, and much turns on the concerns of members of the public about whether individuals will be coerced and what it is that they need to know and what the authority ought disclose.
Right. So the real
voluntary enrollment.
All right, the real issue in clause 10 is that when an individual is enrolling, he or she should be told that even after cancellation, in accordance with the Data Protection Act, some of your information may well be retained. Should we put that in, AG? Is that what you're suggesting?
Chairman, no, I'm saying that when I heard the concerns expressed from the groups, if we look at 10.1, 10.1 tells you that an application may be made to the authority in such form and manner as may be prescribed. So that is to come, and naturally that would be in. And again, my preference is that it be gazetted. Just permit me to connect my my battery's running out. Sorry, Chairman, just give me a pause. Yes. No. So, sorry, Chairman. I'm saying that the clause provides that when an application is being made to the authority, this is in respect of the enrollment, an application may be made to the authority in such form and manner as may be prescribed. I don't know where the technical team is in respect of their formulation of the form and manner that will be prescribed for the application, and then subject to the provisions of this section for enrollment of any individual who is eligible as described in 4. That would be the citizen of Jamaica and persons ordinarily resident in Jamaica. Those are the 2 categories of persons who are eligible for enrollment. Then 2 says that at the time of an individual's enrollment, the authority shall, in such form and manner as may be prescribed. So it could be form and manner as prescribed, that the person is presented with a list to say that you read through the list and you tick off and sign at the end of the day that you agree to it, as comes up many times when you're accessing web pages and websites, when you can't move from one stage to the next unless you consent to the terms and conditions. So I don't know what form and manner will be prescribed for the individual to be told what this clause is mandating the authority to inform them. So A, that enrollment is voluntary and that the individual may cancel the enrollment in accordance with the section 14.1b, and B, in respect of the information collected from that individual for the enrollment. One, of the reason for the collection of the information and the purpose for which the information will be used. Two, of the fact that steps will be taken to verify the information.
No, what else would you like to add to those, AG?
Just a minute, Chairman, just a minute.
No, but you're going through the list. I mean, the list is there.
Chairman.
Go ahead. But
Chairman.
Go ahead.
I beg your patience and your indulgence, sir. That the individual is entitled to access the information and of the steps required for such access, or that the individual is entitled to request the alteration of incomplete, incorrect, or misleading identity information stored in the national identification databases and pertaining to that individual and of the steps required to make such request. Just querying what it is that misleading contemplates that is different from incomplete and incorrect. Because this may tie back to the query that was earlier raised. So what is that misleading here contemplates that would not fall in the category of incomplete or incorrect identity information? Misleading to whom? And from whose perspective?
You want to respond to that, Kamiko? In other words, I can only imagine, EG, that if they put the incorrect data, like the incorrect birth date, that when it comes out, they will ask for that to be corrected. Or if
let's use the example of the gender.
No, so if it is incorrect,
let's use a thorny example. So let's use that example here in terms of the misleading information.
Yes, but it can be corrected. Once the information is incorrect, then they can ask for it to be corrected. So that if it is a gender and they're saying, but I am no female, and the NERA says, but on your birth certificate, it says male, then the NERA can say it is not incorrect because we're using the birth certificate. So unless you can get it, as we were discussing earlier, change in the birth certificate, we're not going to change it. Okay, sir.
So what of the person who say that having altered my gender, your inclusion of the old gender is misleading?
Well, in those circumstances, the duty remain on that person to go and have a change on the birth certificate.
So I'm asking whether we need to have misleading information here, since correctness is what you are looking for and completeness.
So would you like to remove your suggestion would be to remove misleading?
I am throwing it out to the committee.
So you're saying to request the alteration.
Since we have to consider the bill as a whole in terms of its entire scheme and what it is permitting and not permitting.
Okay, so CPC, I think AG may have a point here in that misleading may well be an opinion rather than a factual statement. So if we just say alteration of incomplete and incorrect identity information, because misleading may well be more an opinion rather than an actual statement of fact. What's your position on that, CPC?
Well, Chair, it might leave a gap because there might be circumstances in which information that you give might be technically correct, but it doesn't paint in reality, it doesn't give the information that is required. For example, if you live at an address that's a complex that has more than one unit, and you give your address, which might be technically correct that you live at 5 X avenue, but you don't specify that it's unit this or unit that. That might be misleading. So it's not only limited to the question of gender and those things. There might be other
falls
with misleading might close a gap.
That would fall under incomplete. If you say you live at 10 Dewsbury Drive and left off apartment 10, then that's incomplete. It's not misleading, it's incomplete.
If I may share.
But here again, suppose you say you're married, but technically it's not. The reason why you say you're married is because you have been in a relationship longer than 7 years. I mean, would that be misleading? Because, you know, in other words, we recognize common law marriages. So if one is asked their marital status, you know, so I don't know, AG, if you, keeping the term misleading necessarily damage, you know, the structure, or I don't know what's
Chair, if there is the offense within the enrollment section with regard to persons who provide false information or makes false statements of a material nature with the intention of obstructing or misleading the authority. And I wonder if that is also where that particular gap that the CPC was referring to would exist if we remove it.
All right, but I think apart from that, AG was, or we were discussing earlier, whether the individual, we should add to subsection A and perhaps another F to indicate to the person enrolling that if you cancel, information may well be retained in light of the Data Protection Act. Those are two things to be considered. So AG, I don't know.
Chairman,
yes.
Let me just clarify my point. My point is that when the law is read as a whole, we must be deliberate in our inclusion of words and phrases, bearing in mind what they can be used for, because a statute continues to speak. It doesn't only speak at the time when it is passed, for as long as it remains on the statute book as law in force. It will speak, and it will speak in changing circumstances.
Fine. And as you will appreciate, AG, no law can be exact. And as you appreciate, law is always changed depending on the dynamics of society. That is the nature of law.
Chairman,
yes,
very true. But all I'm asking for is a level of deliberation and intentionality
right.
of the bill.
So the question I'm asking, AG, I don't have any difficulty leaving the term misleading, because I don't know if it will affect, you know, anyone keeping that term, or what's your position?
So remember, my question was, what is contemplated by misleading that would enable an enrolled person to request alteration of his or her identity information that is not covered by the words incomplete or incorrect? That was this question that I asked.
So if I may, AG, there may be a circumstance where the information is not, is ambiguous and could provide more than one meaning, which could be misleading. It's not technically incomplete, it's not technically incorrect, but it is not technically accurate either, and would need to be altered.
I don't know if we can
remember, you know, it is the individual who initially supplies the information in accordance with the requirements of the law for inclusion in the database. And then the information supplied is verified in accordance with the provisions of the law by resort to the documents, that the various documents set out that you mentioned. Let's remember that context.
Mr. Chairman.
Yes, Senator.
I can't see what the issue is that the AG is having, because the provision that we are looking at speaks to the authority, merely informing the person seeking enrollment that he's entitled to request. No, he can request anything, I would believe, for alteration, because he may be of a particular view. If the authority does not accept it, he still accept that position that he's putting forward, and either does not carry through with the enrollment, then the person has an opportunity to appeal. But it is what this provision is speaking to is just the information that is being given to the individual at the time of his enrollment.
Right.
So I think that it should remain as it is, that they are being informed that you can request an alteration of what you believe is incomplete, incorrect, or misleading. The authority, if they request it, the authority does not have to accept it if it is not in compliance with what is expected from the other information, the birth certificate, the passport, or as the case may be. But it's just informing him that he can request it if he is of the opinion that.
Yes.
I accept your explanation, Senator Sinclair, through you, Chairman.
Yes.
I accept your reasoning. Yes.
All right, so can we move on? The next issue is whether we should add a sub-clause to indicate, to inform the person that the information provided may well be retained even after cancellation. So CPC, just make a note of that we can add that at a later date, okay?
Chairman, so is it that it's not considered that it's covered by 2B1, that the person should be informed of the purpose for which the information will be used?
So you're saying that what I'm suggesting could be included in 2B1, is included in 2B1?
Well, I was asking for consideration of that.
No, Chairman,
Yes.
Ms. Grant has made her comment, and I'm looking at 2B1, and I think that it probably should be more specific to include what you are proposing. It can probably be extended to B1 to ensure that it is expressly stated that the information may be retained, or we put it in as a separate provision somewhere. But I think we will be extending the interpretation of 2B1 to capture what Ms. Grant is suggesting.
Okay.
I think it should be expressly stated.
CPC, just have a look
I
at it.
support that.
Yes.
I support that, Chair. It must be expressly stated. It's very important for someone to know that in spite of the fact that they have canceled or they're removed, that their information will still be stored.
In accordance with the Data Protection Act, okay? So CPC,
I will call you back,
make a note of that for me, please, CPC.
Was there anything, or you're just following up on the conversation we had? Wonderful. Yes, ma'am. All right.
All right. Your audience on aging. All right, so that is clause 11 and 10. Could we move to clause 11 then? Just bearing that little point to note to CPC. We'll come back to it for clarity, okay? Clarity in terms of the retention after cancellation.
Yes, Chairman.
Okay, 11, Jamaica. Jamaica?
My apologies, I was still muted. As it relates, I was just indicating we're skipping over a few points in each of the different clauses. But with regard to clause 11, several persons submitted several submissions rather highlighted different concerns regarding the type of information and the amount of information required for enrollment. And broadly speaking, there were two schools of thought. Law enforcement, security, and the technology experts were supportive of the information being required, and in some instances suggested additional information for inclusion in the bill. Civil society, legal, professional, and educational groups, and the public defender, on the other hand, highlighted their concern that too much information was being requested and that that information would not be in accordance with the Constitutional Court's ruling regarding the data minimization principle. So the public defender and the GFJ coalition believe that only some of the information there is required to establish an individual's identity. And in fact, the JFJ coalition proposed that there's a value added tier system whereby there's a basic amount of information, and should the person wish to engage with commercial entities, they may, for the KYC requirements, they would then access that particular service and submit that information for that purpose. The Jamaica Council, the Jamaica Coalition for Healthy Society actually recommended a redrafting of the bill to make it more clear that only some identity information will be collected from applicants and not all. And the technical team's response to that was that the data set that is utilized is necessary to ensure that information is only provided once, and that it will allow for recognition of legal identity. And importantly, it will also satisfy know your customer requirements, because a critical policy intent of the needs is to assist Jamaicans to access the formal financial system. And accordingly, the data set has to strike a balance between the right to privacy via the provision of minimal information and the requirements of access to the financial system as is outlined by the Bank of Jamaica to identify a natural person. And for that reason, the data set that is utilized was put in the bill. Right. So that is that particular point.
All right. So my understanding, colleagues, is that persons wanted more additional factors in 11, but others, like the public defender and a few others, are of the view that too much was being required for identity information. The NIDS, my understanding is that the NIDS team believe that what we have here is strike the right balance. Would that be correct, Kamika?
Right, sir. What a proposal to strike another balance would be to indicate that, to redraft the bill if necessary, to indicate that there are minimum mandatory pieces of information that must be provided by applicants for enrollment. So those would be the facial image, the full name of the person, previous names, date of birth, and sex, nationality, of course, to establish that the person is a Jamaican, and the period of residence for the ordinarily resident individual.
But I would say, why don't we just leave it as it is, even though you're well aware that you may not be able to register unless certain basic information is provided. I don't necessarily think that we need to redraft that section.
Chairman?
Yes, AJ.
All right, so different things are enumerated in clause 11 in respect of the biographic information. I don't know what concern was raised about that in respect of the biometric information. The technical team is correct that has been reviewed.
You're breaking up, AJ. We're not hearing the fully.
I'm saying, Chairman, that in respect of
we're not hearing the word aging.
Let us look at the category, the list under each category to see if all listed there, if all are required, if there is anything that is an alternative to something else. I think that was a concern that was raised and the response that was given. So in order to check, so for example, when we go down to C, 11(1)(c), and we see tax registration number and driver's license number. To the best of my knowledge, the number on the driver's license, which you use as your driver's license number, is your TRN number. I don't know if we have any situation outside of that. That is the system that I know under, but not everyone has a driver's license. So if you don't have the driver's license, you may require the TRN, but it is how it is stated. I think that we just need to check. So for example, initially we had toe prints if the person didn't have fingerprints. I noticed that is not there anymore though. So what it is that would enable the unique identifier? What is the minimum that is required? If anything other than the minimum, because it's least impairment of the right that the law requires. And the right to privacy has an informational side to it. So it's just to see. So you're asking for the full name, date of birth, country of birth, place of birth, those are standard. Name of mother and father, also standard, even if persons may not know a father's name. Whether the individual is male or female. So this is where you had suggested.
Right, we put as stated
in a
we could add your CPC in 6, whether the individual is male or female, as shown on the person's birth certificate. Would that be okay, CPC?
Yes, Chair, I would phrase
as recorded on the birth certificate.
As indicated on the person's birth certificate.
Okay, so we're going to add that there, okay? All right, go ahead, AG.
Chairman.
Yes.
Chairman, may I ask that instead of indicated, use recorded? It might just be a finite, but you know, in time, I'd rather that it be recorded than indicated.
Okay, that's okay, CPC, as recorded on the person's birth certificate, as recorded. Is that acceptable, CPC, instead of as indicated?
Yes, Chair.
Okay, but AG, what we have in 11 is a menu of you know, factors that could be collected. I suspect that some may not be necessary because they don't exist. The person, as you quite rightly said, may not have a driver's license or a passport or even TRA.
So you may recall, Chairman, that one of the concerns raised is that while that explanation is accepted, is whether the way it is drafted actually reflects that.
You're old enough to know that by now. I'm not sure why you're making that comment.
Senator Hill, please
Minister Hill,
turn
off your audio.
The PS said that they are responsible.
Senator Hill. I'm saying, Chairman, you gave that explanation and it was accepted, but let us just ensure that how we have worded it is actually indicating that. That is really the thing. So the opening, the chapeau says that the following may be requested by the authority from an individual for the purpose of enrolling.
Right.
It says may, it doesn't say one as opposed to the other, even though it may be implied.
Right.
So I think that was a concern.
So my view then, AG, is that since it's not mandatory, it is a may, I don't see any reason why we should change anything.
Chair,
yes.
I want to make an intervention at this stage, and I remember being very struck by the submission of Jamaicans for Justice. What they pointed to was the government's white paper, which had suggested that the minimum requirement for establishing your identity is what the government would be relying on. And I think that we need to look at the identity information, which may be asked for, and maybe means will be, in my view, because the most entities don't have that sort of discernment. Once they get a list of everything, that's what they're going to require. And the question which we have to ask ourselves is this, all of this information really vital in order to establish one's identity? If we're talking about the principle of minimization, that becomes even more critical. When we're drafting legislation, we must anticipate that there are going to be persons who might be inclined to challenge it. And so we anticipate some of the problems which we will have and ensure that it does not follow. So I looked at the biometric information and I wanted to know, did we really need to go beyond a facial image? For example, if the fingerprints as defined by the Fingerprints Act, by the way, also includes the toe print and so on. It's a very wide definition and is not restricted to fingerprints in that context. And I wanted to just ask the committee to pause to consider whether, in fact, all of this data was going to be required in order for one's identity to be established.
Well, bear in mind, why I would not support removal of fingerprints. A person's facial image can change. And therefore, I would not want to use a facial image alone. So certainly, I would want not only facial image, but fingerprints. Because, you know, I accept that in most cases, the facial image might be sufficient. But persons can do a plastic surgery and change your facial image. So I
remember you pointing out, Chair, that as we age, our facial images change.
Absolutely.
I remember that Joint Select where you gave that example.
Absolutely.
But my point, the point that I'm making is in a way a different point, which is, does the committee believe that all of these elements are vital for establishing identity?
Well, I would say yes, but can you think of any that we could exclude Senator Scott Munford?
Well, it's a lot of information.
No, but
and I think, as I said,
which one would we want to delete?
I would have felt that the fingerprints were not necessary.
But
but you asked me what I would delete, so I'm just putting it forward. Not you have a difference of opinion, but I'm just putting it forward. And the signature, I don't think advances the case much because people's signature also change.
Right, but to the extent that
where in C, I am satisfied that it says where applicable, so that you're not expected to produce all. So you have a choice. The authority would have a choice as to which one in the circumstances would be acceptable.
Right. So the issue there is in B, Romans 1, 2, and 3. Either of them may change. Like in 2, the fingerprints may change or they might not be accepted because a person's fingerprint might erode with time. So that the fact that 1, 2, or 3 could change gives more reason why all 3 should be included.
May I ask a question through you, Chair?
Sure.
Senator.
I have my hand up. Doesn't the hand up mean anything, please?
I can't see.
He can't see it.
You can't see it.
That's why I turned my video on and
turn on your video.
Right, go ahead then. I'll wait.
Right, after AG.
Member Hill. Member Hill.
Go ahead, AG.
I will defer to you.
I mean, it's the AG. Absolutely, AG first. It's the AG. I didn't know that. Go right ahead, AG.
You're so mischievous. Chairman, to Senator Scott, to the extent that we accept that what we're seeking to do is to provide a unique form of identification. What is enumerated under the biographic information does not allow for that uniqueness. Persons may have the same name, born on the same date, in the same country, at the same place. perhaps even with the same parents, who knows? What would you say for the biometric information that would enable the objective of a unique identifier, if not inclusion of the fingerprint?
I said already that in my view, the facial image would be sufficient. The minister has differed with me, and obviously so are you. The question that I think we should be discussing is one, what is the minimal required to establish this unique identity? And two, are we likely to infringe on any rights to privacy? And once we have overcome those two hurdles, then I think that we just proceed in the spirit of which the enactment is being done.
Okay. All right, Senator Hill, you are the...
Yes, and on the principle of minimum requirement,
turn on your video if you don't mind, Senator Hill.
Not at all, sir. You can see me right there.
I can see you now.
The issue, the principle of minimal requirement is important, but so is the question that you ask, which ones would we drop? Certainly for me, 11B, nothing there should be touched. You really do need the facial information. You need a fingerprint and you need a manual signature. You have to sign to say, yes, I saw this document 20 years ago. If it comes up 20 years after you sign it, to say, yes, I was there, I signed the document and I gave it. Or authority can say, you may forget, but you were here on that day and here's a signature. So I think those three things are sine qua non for the discussion. Others, said Scott Martin rightly identified C as being really optional. You're going to pick one of those as the case may be, but I think B, there can't be a minimum list that is shorter than the ABC in the 1, 2, 3 in B.
And bear in mind also, Senator Scott Motley, that my understanding is that the 2017 bill that was ruled unconstitutional, it had many more biometric data, including retina identity, and the possibility, but it's no stronger than that, possibility of other DNA and other unique methods of identification. So I would say that these three are basically the minimal. That's my view. That would be required because either of the three could change. And that is why I say that all three should be used, because with age, facial image may change. With age, our use fingerprints may be deleted. And with age, and in fact, not only with age, with choice, the signature may also change. So I would not disturb those three. In fact, I think there were contributions that said we should have additional biometric data.
That was from the security personnel, as I recall.
That is correct, right? So, but we are not supporting.
Who would want a multitude of information?
And I accept that because.
But Minister, I've made a point. I am not going to delay you with it. I just wanted it to be carefully considered, especially in light of the judgment. Right. Just that we have the minimal necessary.
And that's my view.
Thank you, Chair.
Right. So I don't think there's any other point on 11.
Mr. Chairman.
Yes, please. Go ahead, Senator Singh.
Points. Can I be reminded in respect to 11(1)(a) Roman numeral 7, where it says principal place of residence and any other places of residence. Are we leaving the words after the first residence, principal place of residence, and is going to be remaining?
What's your suggestion on sentencing?
I was just thinking that is a little, we were just discussing too much information and any other places of residence. What's the purpose of that? as against you providing the principal place of residence. And what constitutes any other places of residence? If I stay at another location for a weekend at another place of residence, I don't know what it means. And also in 11C, I had suggested in the early days of the JC that we include a Roman numeral 7, allowing for the use of the student registration number so that it would be consistent with 12(2)G, where an identification card issued by an educational institution as defined in the Education Act. It affords the opportunity for the person who is attending school, who is issued with a student registration number, but may not have a TRN, a driver's license, may not have a passport, NIS. Well, they could be on path and would not have an electoral registration number. For the student registration number, if that could be included as Roman numeral 7 in 12(1)C.
So you're saying, I have no difficulty with that sentence, Sinclair. The NIDS team, do you have any difficulty with that?
Well, Minister, this is Graham. The question I asked is the reliability of these school cards. My own experience is that they are quite unreliable. Should we insist on putting it in all the others? There's some kind of process and standardization.
Right. So I think the point, Senator Sinclair, that Senator Graham is making, unless they are properly authenticated, they may not be reliable, and therefore, even though they could be used for verification of identity, they don't necessarily want to put that as a part of the menu of information in the NERA.
I appreciate it. So that in relation to, well, we haven't gotten to 12, but it is there in 12(2)G where the identification card can be used as a verifying.
No, but yes, they may use it to verify the identity, but they don't necessarily want to keep it as a part of the NERA.
Right.
The unreliability, as Senator Graham is saying,
Right,
of that information.
Thank you very much for the clarification. Thank you.
All right, thanks then. In fact, we can actually move to, if you persons don't mind, to 12.
Sorry, Chair, before you move on, was there a decision on 11(1)(a) Roman numeral 7, whether we were deleting the words "and any other places of residence"?
What are the committees? Should we just use the principal place of residence?
You probably could just put "where applicable," although others is suggestive of it. Some people may not wish to give it, some may wish to give it. For example, persons who have a place of residence in Kingston or out in a constituency, or for whatever reason.
I agree with you that if you don't mind, members, we could just put "where applicable" in bracket. Okay. All right. Okay, thanks. Section 12, which is the last section we are going to deal with. This is just for verification. Any concerns there, Kamika?
Yes, Chair, thank you. Well, JAMPRO has suggested that the TRN be utilized for verification. JCPD, the Jamaica Council for Persons with Disabilities, they had recommended that an ID or disability certificate from that entity could be used as a verification document as well.
But would they be included in J, in subsection J?
Yes, sir, yes.
Okay, so that it doesn't really matter.
Right.
So basically, go Go ahead.
Right. So JETS had suggested that more detailed information regarding verification should be included because the verification process that's stated there only refers to the requirement to submit documents. It doesn't refer to engaging with other entities in order to assist with verification. However, the technical team's response is that the bill adequately addresses this issue via clause 8, I believe, where the authority is empowered to, and other public bodies are actually required, to cooperate in order to achieve the functions of the authority. And the bill also empowers the authority to prescribe any regulations necessary to allow it to fulfill its functions. Some uncertainty was also expressed by the Jamaica Bankers Association,
But to my mind, though, Jamaica, this is a matter for the NERA, for the NIDS team or the NERA, to see what would allow them to feel confident that a person's identity has been verified.
Right. So
I would say that on the J, you know, anything else, any other document that will assist them is what is really being looked for.
Right.
Okay?
Yes.
So, and it may not be possible for us to enumerate all the other documents.
And that was the suggestion, actually, sir.
All right, so I think 12 is just a question of verification. Senator Hill or Graham?
Graham. May I ask what was the concern of the bankers?
They wanted to know whether or not the documents that were being referred to were local documents and overseas documents.
Is any document?
Right. We don't believe that there's any constraint in the bill, and accordingly, we don't believe that needs to be specified.
So what they would like you to be able to use overseas documents as well.
Yes. And that is a part of the intention, because we will be having persons who are ordinarily resident. So we would have to be utilizing overseas documents.
All right, I promise everyone that we would not go beyond 10, so I don't want to break my promise. So at this time, we're going to sign off and we start again tomorrow morning on 13, okay?
The only thing as you've signed off, Minister, on 12.
Yes.
I would think normally, if the bill say you need A, B, and C, then some kind of territoriality may be implied. Isn't that so?
Admittedly, but remember knowing that the birth certificate and passport may well be a foreign birth certificate and foreign passport.
Okay.
So I don't think you need to necessarily say a Jamaican one. In fact, it would be too restrictive.
Yeah, no, I'm not trying to say Jamaican. I'm just thinking about what the bankers have said.
Oh, no. But that would have to come under J, any other document, you know. All right. Okay, so is that okay, colleagues? I know I'm imposing on everybody's morning schedule, or not me. We're imposing on one another's morning schedule. So we're going to ask an adjournment at this time. So can someone move for the adjournment, and we go tomorrow at 8:30 again?
So move, Chairman.
Thanks, AG. Thanks again, everybody. And please 8:30 again tomorrow morning. Anila, are we going to use the same link?
Yes, sir. I'll resend this afternoon so it doesn't, the email doesn't get lost in others today.
And we start again.
And whoever is sending the email, please, can you make sure that I am on it, because I'm not on your big list right now. I'm surprised. And that my assistant has asked Mr. Vernon.
All right, it's the same link. Okay. It's the same link. Okay, so thanks again, everyone. We see everybody tomorrow morning again.
We work to make communities safer, by essentially looking at the structure